SB 68 is going to affect regular Georgians in ways that you might not even realize. I'm Michael Coker, a personal injury lawyer with over 15 years' experience practicing Georgia law, and this is the Georgia Legal Talks podcast. SB 68 was a bill that was passed by the legislature during this legislative session. Governor Brian Kemp made this his landmark legislation. Some are saying that he wants to run for U.S. Senate, and he's using this as kind of a springboard for donations or to further his political career. But SB 68 is going to affect regular Georgians in ways that you might not even realize. Now, before we start talking about SB 68, you got to understand how personal injury lawyers and personal injury cases work to begin with. Personal injury cases are taken on what's called a contingency fee basis, which means that a lawyer does not charge you an upfront cost, does not bill you based on the work they do. Instead, they collect a percentage of the amount that they recover. Because of that, the lawyer doesn't get paid unless they win the case. And so, in essence, what ends up happening is the lawyer will only take cases that they know that they have a good chance of winning. So, as much as people talk about frivolous litigation and frivolous lawsuits, I'm not saying that there's not people out there that try to bring these cases. But I am saying that they would have a very difficult time finding a lawyer to take it because these cases are expensive. Sometimes my cases can cost $50,000 or $60,000 to do. I'm not going to spend $50,000 or $60,000 of my hard-earned money on a case that I don't think has any legitimacy or lacks merit because I may not win that case. And so the contingency fee model, in essence, is a way that the Georgia can be assured that lawyers are not bringing frivolous cases. Despite that, certain insurance companies and insurance lobby groups and chambers of commerce have said that their insurance premiums have gone up substantially. Now, I'm going to take them at their word. My insurance has gone up substantially, so I'm going to believe them when they say that. But I think the question we have to ask ourselves is why? Is it because of lawsuits? Is it because of insurance profits? Is it because of storms that have been more devastating? All of these things play into the situation and what causes insurance premiums to rise. Well, Governor Brian Kemp decided that this was going to be his number one issue, that he was going to pursue this. And some people say that he's planning on running for U.S. Senate. And so he's going to use this as kind of a springboard to ask for donations from corporations or from insurance companies. And so that's why he wanted this passed. And he, in essence, said that he wanted to make tort reform his number one priority. And so what that means is that we are dealing with a situation where the governor wants this and that he was pressuring the legislators to ensure that it got passed. This session in particular was probably the most interesting I've ever seen because individual legislators did not really have much of a say, and they kind of had to either take the governor's bill or risk him supporting their opponents at the next election. So what does this mean for us and for our situation? And what does this mean for SB 68? Now, SB 68 predominantly deals with three specific things with how injury claims are brought. And each of them are going to have a very substantial impact on how you do your case. Now, I want to talk about each of those three things so you can kind of understand what this law is, how it works, and what happens. The first thing on SB 68 deals predominantly with what's called the collateral source rule. So in Georgia, we had this rule that stated if you have health insurance and the health insurance paid less for your medical bills than, say, someone who didn't have health insurance, that didn't matter. That you, the insured and the uninsured person, should collect the same amount, meaning that that insured person shouldn't be punished for being responsible and buying health insurance and not being able to collect the same amount as their uninsured counterpart. So how does this work? Let's say when you go to a hospital, let's say your bill's $100,000. If you don't have insurance, you're probably going to pay that $100,000 in full. Or you can call and try to negotiate it down, but you're going to have a difficult time negotiating it too far. But if you do have health insurance has a fixed rate that they pay. So let's say your bill again is $100,000. Your health insurance may only pay $20,000, and then they may have a deal with the hospital to write off that other $80,000. Under SB 68, now, if you have health insurance, instead of being able to collect the full $100,000, you're only able to collect that $20,000 that your health insurance paid. Now, why is that a problem? Because in many cases, you have to reimburse your health insurance dollar for dollar for what they paid out in the case. And so when you go to the at-fault person and collect that $20,000 now, you're going to have to immediately turn around potentially and pay that back to your health insurance. And if you don't, they have a right to take that health insurance away from you. So it's very, very important. And so now, in a weird way, the uninsured person can still present the $100,000. Of course, the defense can argue that the bill's not reasonable, but they're not going to be punished by only being able to show the reasonableness as the amount that was paid by the health insurance. And so it creates this weird incentive where you're almost better off in an injury claim not having health insurance than if you're responsible and paying your premiums and doing what you're supposed to get health insurance. Now, a lot of my clients are frustrated when they find out they have to reimburse their health insurance because you're paying your premiums, you're paying your deductibles, your copays, and why would you have to pay them back if you're paying your premiums every month? That's federal law. That's not even a state law. That's a federal law. Again, the insurance companies have powerful lobbyists, and they require that payment in full. So that's the first element of SB 68, the tort reform bill, is that it does allow for those who have insurance to only now collect the amount that the insurance actually paid. So obviously, that's going to take the amount of those settlements down substantially and really is going to jeopardize how much those clients with insurance might get in their pocket after all the medical bills and paid and the insurance is paid back in those items. The second aspect of SB 68 deals specifically with what's called negligent security cases. Now, negligent security cases are cases where, let's say against an apartment complex, let's say there was a history of crimes at the apartment complex knew about it, they took no action, they didn't fix maybe a broken gate or a broken fence, or maybe they refused to hire security like they were supposed to. And then so what ends up happening is that a crime ends up happening, and then you end up being the victim of a crime. Well, in the past in Georgia, you could sue that apartment complex, and you could say, hey, you guys did not take proper action. You did not do what you were supposed to. You knew this complex was dangerous, and you didn't do anything about it. And you could get them to pay for your medical bills and your pain and suffering. Those cases after SB 68 are effectively gone. And in particular, if you watched any of this over the debate about SB 68, one of the primary groups that this affects is victims of sex trafficking. Think about a hotel, right? So let's say a hotel owner kind of had an idea or knew that sex trafficking was happening in the hotel, but didn't report it to police, didn't do anything about it, and really just wanted to collect the money. As long as that room was rent, they were going to keep collecting the money. Historically, in Georgia, those sex trafficking victims could then sue the hotel and say, no, you turned a blind eye, you did not pay attention to this, and so therefore I should be able to collect my therapy bills and pain and suffering from you as the hotel. Effectively, those cases are gone as well, potentially. So that's another major issue. Now, there are some limited exceptions, but it is something now that those cases are substantially more difficult. So what does this mean? It means that regular Georgians like you or I might be less safe. So if you're at the mall, for example, and there's a history of gang violence at the mall and the mall doesn't do anything about it, and your child is hit by a stray bullet, you can no longer sue the mall. And so the fear that we have, right, is that as trial lawyers, we were kind of the last line of defense that required some of these commercial entities, these apartment complexes, to have security to protect their patrons. And we're worried that now that law is gone, that you might be less safe. Because now when that mall is deciding whether or not to pay an expensive security guard team to come work the mall, they might say, no, that's going to cut into our profits. We're going to cut it. Whereas before SB 68, they basically felt, you know what? We might get sued if we don't hire that security team. And so they would go hire them. And so that's the fear we have on negligent security, is that as a society, we might actually be less safe now that we're dealing with a situation that those cases no longer exist, because there's no longer that threat of a lawsuit happening that's going to make that business or that mall or that apartment complex take action for security. So those are the first two main ways that SB 68 deals specifically with how lawsuits are brought. The third way deals with how evidence is presented at a trial, predominantly two ways. The first way is traditionally in the past, we as lawyers would show up at a trial, you'd have a jury, we'd present evidence about liability, who was at fault, damages, causation, medical information, all at the same time, give it to the jury. They would go back to the jury room and then make their decision as to who was at fault and whether my client was hurt and what injuries were caused by that negligence, come back and give a decision. Well, now the new SB 68 also does what's called bifurcates the trial, which means now you'll show up as a jury, you'll present evidence on liability only, meaning who's at fault, jury will go back and deliberate. Then they'll come back, make a decision on who was at fault. Then you'll have part two of the trial, and then you'll present medical evidence, medical testimony, things of that nature. The jury will go back, come back, make a decision on that. And so in essence, what it does is it turns one trial into two. And so who does this affect? It basically affects jurors. Instead of now being at the courthouse for 2 or 3 days for a trial, they might be there for 4 or 6 days, because it might take twice as long because now there's 2 trials instead of 1. It'll affect judges because think of how many cases judges have, and now their cases are going to take longer and more time, and it's more energy, and so it's going to affect them, and it's going to make their cases flow slower than normal. And so this is definitely something that you need to watch out for if you're a juror, or also if you have a case, is that now these cases are going to take longer when you go to trial. The second item is that the lawyer can no longer talk about how much the case is worth until the very end of the trial at closing argument. So historically, lawyers like me, would stand up at the beginning of the case and say, "Here, does anyone in this jury feel like they couldn't award $1 million if the case and the evidence supported it?" And we'd want to make sure that you felt comfortable awarding what we felt like was a fair amount of money. Well, that can no longer happen anymore. So now the only ability for us to say what we believe the case is worth happens at the very end of the case, at the very end of the trial, in what's called closing arguments. So those are two ways that the procedure is different. There's some other procedural things in SB 68 too, and how the timing of when things are filed and this or that. But those are the three major aspects of how SB 68 affects your ability to bring a case as a plaintiff. And I will say this, is that, are there frivolous cases out there? Probably. I'm sure there are. I'm not going to say that there's not. But my fear as a lawyer is that sometimes we take things that we think are a problem that really are not that big of a problem, and we overcorrect, and we end up going too far the other direction. And so what my fear is that we're going to be in a situation where we've gone so far the other direction that people with legitimate injuries, like sex trafficking survivors, or people who suffer from crime in an apartment complex, or people who have exorbitant medical bills that all get paid by health insurance that now they can't collect anything but that amount. These are the people who are going to suffer, and these are the people who are not going to have the case that they traditionally have deserved under the law. And so those are some aspects of SB 68 and how they might affect you and your case. If you have any questions, obviously I'm more than happy to answer them, but I just wanted to explain and talk a little bit about SB 68, what it is, how it affects you, and why you need to know why action that's taken at the Georgia Capitol is important. Things that affect your rights. And you might not even realize that you need a lawyer in a personal injury claim and how these affect you until it's too late and something bad has happened. And so definitely, stay in touch with the people who represent you, your representatives and your senators, and be sure that you are educated in the effects that these laws have. And so, again, my name is Michael Coker. I'm a personal injury lawyer in Lawrenceville, Georgia. If you ever need anything or if I can ever help you, feel free to reach out, and stay tuned, and I look forward to talking to you next time.